Hey, on to chapter 18, talking about that. I guess you see in the background there, we got Mr. Mark Mariani, wide receiver now for the Chicago Bears. Of course, this was when he played for the Titans. He was home in Havre signing some autographs and whatnot. So, yeah, he had a good game. Watched Monday Night Football last night. He had a good game. He got in, besides just returning kicks, got to play wide receiver and caught a couple passes, and the Bears won, so congratulations, and passing on that word to you all. So onward we go. We get to talk about, by the way, he was a very good student too at the University of Montana and majored in finance, something I would highly recommend for any and all of you. We're going to talk about stuff that now would be more personal finance, but certainly gets into some legal things. Got your credit score here, the Reader's Digest article. I may have to post that. The link doesn't work, but I do have it. It was in 2009, but it's pretty interesting. You know, it talks about how they set it up and those types of things. And obviously, I was in the industry for quite a while, and so I kind of know a little bit about some of this stuff. But it is. Yeah, I'll talk more about it as we go along. So rather than give everything away now, I think we'll talk about credit scores kind of as we go along a little bit here. So I would encourage you all, though, to have knowledge about your credit history and perhaps about your credit score. I think that's extremely important. Okay. Exclusive legal fence of property protects us in the possession, use, and transfer of what we own, yet we cannot use or transfer what we own without limits. So I don't know why that's in this particular chapter. It's more of a property type of a thing, but there are limits yet to what we can do. So we're going to talk about consumer protection. Was on there, and some of this gets over into the credit. It's consumer protection, both physical things that we might buy or tangible things that we might buy, but also consumer protection on the credit side. So who's a consumer, right? Has to be a natural person. So corporations are not really considered consumers, or companies or businesses, right? LLCs, any of those types of things. Can incur debt. Okay, when we talk about debt things for certain consumer protections, right? Personal, family, or household purposes. So regulations about consumer protection prohibit unfair, deceptive acts. So much like we just talked about the SEC, right? It's a lot about information and making sure that proper information is disclosed. And a lot of cases, in these cases, not only that, they have to be proactive, about that information, warnings and those types of things, right? There can be advisory opinions from the Federal Trade Commission. There's certainly industry guides, so industries get together, talk about, the things that they make. While our car manufacturers, I'm sure, love to compete, and they do, and they want to beat each other up, but they also have guides, and they share information about safety features and whatnot. For example, I forget when it was, but it was several years ago, and one of the major car manufacturers came up with a major safety feature, and they shared the information, even though they could have probably patented that, and maybe they did get some money out of it, but they were willingly shared it with the other car manufacturers because it was something that would make things better for everybody. So trade regulations, they have rules, and of course they set those up and whatnot. And we're not talking about foreign trade. I don't think so there. No, we're just talking about exchanges, the rules that we have about exchanges and trading that we do here within the U.S. So FTC, although it can also impact, of course, foreign companies. So FTC and trade practice regulation, right, there can be penalties and remedies. Civil, right, corrective advertising can take place, rescission, so they can rescind, somebody's ability to operate maybe, especially foreign competitors. Consumer refunds and damages can take place, and there has to be public notice oftentimes, right? Prohibiting deceptive trade practices, right? We have to consider somebody that's a reasonable consumer. There have to be express and implied claims. There are, with any product or service, there are express warranties, right? But there are also implied warranties. Okay? there can be misimpressions. There has to be materiality, and again, similar to what we talked about last chapter when we talked about that with the SEC. And there has to be sufficient evidence to support the ad. And we see, a lot of these, with different companies and what they can run in terms of advertising for their product and what they can't, et cetera, et cetera. One of the famous ones I kind of remember, it goes way back, and I'm not even sure this product exists a whole bunch, but it's Listerine, which is a mouthwash. And Listerine ran ads that said it kills the germs that cause the common cold, and which was the truth. Okay, there was no question that it was the truth, that if you put it in a petri dish, the germs, the rhinovirus, and you added Listerine to it, the Listerine would effectively kill the rhinovirus. But the problem is that there was absolutely no indication that gargling or using Listerine would help prevent you from getting the cold or shorten the time span or anything like that. And so it was deceptive. And Listerine paid a big fine, and they had to run corrective advertising for quite some time. So FTC today, right? The mission varies according to orientation of the President and the Congress. Yeah, and obviously, we're seeing right now, of course, a president that's pretty proactive about going after companies and some of the claims and whatnot that they make, and some of the things that they fail, to disclose, et cetera, et cetera. So the FTC has great discretion, okay, in determining what's deceptive or unfair, et cetera, et cetera. They also administer some other acts, the Equal Credit Opportunity Act, which is much like the Equal Employment Opportunity, okay, Fair Credit Reporting Act, and Truth in Lending, which we'll talk about as well. So Equal Credit Opportunity Act, right, is set up, and it's much like the Equal Employment in terms of very, very similar. We thought about them as being almost identical when I was in lending, right? You prohibit discrimination based on, and where have we seen these, right? Sex, marital status, pretty much similar things to what you would see in the Equal Employment Opportunity Act. Protected classes, can't do that. It probably gets a little bit more in depth in certain things, redlining and some other things like that you don't really need to know a lot about unless you get into banking. Penalties for violations can be actual damages, punitive damages, right? Legal fees, legal costs, can be an injunction. And again, oftentimes, and in fact, ours were imposed or regulated by the Federal Reserve. Okay, that would come in and send examiners and whatnot in, and so there's some overlap there. But a lot of times, remember, we talked about consent decrees and whatnot. That's what would probably take place 95% of the time. A cease and desist order could take place, if the acts were pretty egregious. So, Fair Credit Reporting Act, so we've gone past Equal Credit Opportunity, and we're into Fair Credit Reporting Act, right? This is when we talk about our credit scores or credit reports, right? Credit information, right? And it talks about consumer rights, either when they're denied credit or insurance, okay? Can a credit report be used for insurance? Yes. Can a credit report be used for landlords or an application to lease? Yes. Can a credit report be used in an employment practice? Yes. As long as those folks disclose to you that they plan to use that information, they can. Okay, they can. And so there can be broad uses for credit reports. How come it can be used for insurance, even car insurance? And they fought that. They fought that hard here in Montana, but insurance companies are able to prove that people with good credit actually are better drivers, number one, and number two, they pay their bills, and so it's less cost of collecting and those types of things, and so they deserve a lower premium according to the insurance companies, and so they're granted a lower premium, based on their credit reports. So what does a consumer report contain, right? It contains information about your character, general reputation, da 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 da. 3 days notice to consumer. I don't know what the heck that would be. Investigative consumer report, character, general reputation, etc. 3 days notice to consumer. I'm not sure what the 3-day notice to consumer is, and you might check that in the book. Reasonable procedures credit agencies must observe. So credit agencies, there's three major credit reporting agencies in the United States. I think we talk about those a little bit later. So, and they have to when they publish information, et cetera, or when they collect information, when they disclose information, they have to go through those reasonable procedures. So if you're denied credit, right, you have a right to be told the name of the agency making the report. Okay, you can require the agency to reveal the info in the report, okay, and you have the right to correct or demand that it be corrected, okay. You also can put a consumer statement, okay, your own statement into your credit report that maybe talks about the issue, okay, that led to the denial. Okay, you have those rights to do those things. I didn't see this one very often, but occasionally I would see where a consumer had made a statement, regarding a certain action or something that had happened. I hope we get more. Yeah, we're going to talk more about credit reports a little bit later. I know it's in here. So, Truth in Lending Act. It was called a Reg Z. So, I don't know if Reg Z will come up in the PowerPoints, but that's what we called it in the banking industry. Reg Z had to do with the Truth in Lending Act and how it was regulated by the Federal Reserve Bank and whatnot, and what banks anyhow. And it might have just been Reg Z for banks. I'm not sure that it applied to other finance agencies, but how we had to act and how we had to disclose items to potential borrowers, right? And, to avoid uniformed use of credit. I have a feeling that's supposed to say uninformed use of credit. Yeah, that's got to be uninformed use of credit. Okay, and what that means is that kind of like, again, with the SEC, if you're going to go in and borrow money, you should have the right to understand what the terms and conditions are. And as you might think, somebody that's sophisticated in finance or whatnot can obfuscate all kinds of information. There's all kinds of ways. I mean, I could make stuff so complicated that a finance major might not understand it, right? And so we've tried to break it down so that there's at least some simple information that gets disclosed. What I'll tell you is if you go out and you borrow any money and you look, okay, if you're at a proper place that's doing it legally and not seeing a loan shark of some sort, there should be something called a Fed box, and it's usually outlined, okay, and it usually appear on the finance document, and that should have disclosures of certain things on there, fees and whatnot associated with the loan, but it'll also have a proper disclosure of the APR, or annual percentage rate, and the finance charges and how that's incorporated into the APR. That should give you the ability to make apples to apples comparisons with other types of loans, because as you know, different places they might charge you a fee up front and this place doesn't, and how do you make those comparisons? And this Truth in Lending Simplification Act was designed to try to do that for you so that you can make apples to apples comparisons. And obviously there can be civil and criminal penalties for companies that don't do that. So transactions that might be covered, right? Any lender in the business of extending credit. Again, the debtor's a natural person and not a corporation or a business. And what that means, our disclosure requirements were far more onerous when we were lending money for consumer loans. Go back to the definition of a consumer, right? Than they were for business loans. Okay, a business loan required almost no disclosures. The assumption is that business people should have an understanding of these things, right? Okay, whereas a consumer may not. Okay, and so the disclosures were far more difficult to make for a consumer versus a business. Finance charge may be imposed, if would be included then if there is a finance charge. It's included under the Truth in Lending Act. And again, if the credit's obtained for personal, family, household, or agriculture. Now, agriculture was, for us, for the most part, was considered business. We didn't have to disclose any more for an ag borrower than we did for a regular business borrower, because they were considered one and the same. Fair debt collection. So how do they go about doing that, right? Covers consumer debt collection, protects against certain debt collection agency techniques or things that they will do that can be abusive. Okay, agency must be in primary business of consumer debt collection for others is who's covered, right? Banks are also covered, even though they don't do it for others, but they're certainly covered by the Fair Debt Collection Practices Act. But debt collection agencies, for example, our local credit bureau, the Credit Bureau of Havre, is a agency that does collections for others, okay, and they're governed by rules and regs and what they can do in terms of fairness and how often they can call you or what times of the day they can call and things like that. So if you're a debtor and you've got somebody that's calling you and trying to collect, okay, what can you do then to maybe stop these things? One, you might have to give written notification. Phone call may not do it, okay? And if they're harassing you at work and you say, hey, quit calling me at work, and if you give them notification that they're not supposed to call you at work, they shouldn't. It might jeopardize your job, and so a simple notification will stop them, but you might have to put that in writing, okay? And if they abuse that, then remedies, the debtor can sue for actual damages or potentially a fine. And there's state laws, too, that provide some protections. I don't know that Montana's state laws go any further than the federal laws. To my knowledge, I don't. Okay, so the Consumer Financial Protection Act, and this came about as a result of the credit crunch that we had in 2007 and the subsequent Great Recession, right? But it administers, right, the fair debt collections, equal credit opportunities. So all these fall under now, and these all existed before, so they just put them under one, looks like one particular agency that then has sub-agencies. And the authority certainly overlaps what the FTC was. We talked about the Federal Trade Commission in terms of deceptive practices and those types of things, which has to do with other products in addition to lending types of things, but they overlap certainly. Okay. We're going to talk a little bit about bankruptcy, right? So what happens? I get the Great Falls Tribune, and I think at least once a week they publish in there the names of people and businesses that have filed for bankruptcy, right? And it's a procedure to handle debt when there's an inability to pay. And let me say too that as a banker, and I've fought, I don't know if that's a good word, but tried to collect from people oftentimes who used bankruptcy to protect themselves from paying back debt. And I always hated when somebody filed bankruptcy because it would stop actions that I was engaged in to collect, and it forced me to go through courts and on and on and on. But I would say this too, I'm a big supporter of bankruptcy. In other words, I don't think that people would take chances, especially on the innovation side and business side and entrepreneurial side. They wouldn't take those chances unless they knew that there was a backstop, okay? And I didn't have much sympathy for the people who borrowed too much on credit cards and vehicles and those types of things and didn't pay it back. But I had sympathy for people who were entrepreneurs that took chances and wanted to start a business and gave it a good effort. It just didn't succeed. That happens and if they could get some protection through bankruptcy, that was okay. I also had a lot of sympathy for people who incurred medical debts beyond their control, and those could be handled also in bankruptcy. So what's the procedure? Well, if you're to that point, a voluntary one involves filing a petition. Involuntary is when the creditors can force you into bankruptcy, okay? Creditor must be owed $2,300 if to an individual or from an individual if you're going to force them. Okay, and there's 3 chapters that we want to talk. Evan only has 2 here, but Chapter 7's we're talking about consumers. Though Chapter 7 is the liquidation of assets. That means that basically you're wiping the slate clean, and so you'd go into a bankruptcy, and the judge would tell you then that, well, we're going to have to sell everything. Might include your house, might include your car, might include some of those things, but there can also be exceptions. And for example, you can exempt your house in bankruptcy. However, you're going to have to keep making the payments. Okay, and in fact, when I had people file bankruptcy, maybe they had a mortgage loan with me or whatnot, and they reaffirmed that debt. They were under court order to pay the debt, at that point in time. It became kind of forceful. It was not a bad thing from my standpoint, right? The ones that you lose on, of course, were more unsecured debts and whatnot. Okay, so you can you can absolve yourself of debt. A lot of times it was unsecured debts that went away then, credit cards and those types of debts. But debts like for a vehicle, you might need a vehicle to get to work and da. So the court would say, yeah, we're going to allow you to keep your vehicle, but there again, you're going to have to keep making the payments. Chapter 13 is called an adjustment of debts, and there's quite a bit of latitude, but Chapter 13, they also call it a wage earners plan. And what that does is a restructuring oftentimes too of debts. So I saw a lot of Chapter 13s when we dealt with BGEN medical expenses, oftentimes beyond a person's control. And what that allowed, it allowed them to continue to make payments, okay, but it structured it and it put again the collection practices of the hospital or whoever they had hired. They kind of had to stop, and the court would examine your finances and say, well, you know what, you can afford to pay $250 a month and no more, so that's what you're going to pay, and that's what they're going to accept, and that was that. And again, you were under a court order to pay that, and they were under a court order to accept that, and sometimes a year or two later they might go back in and readjust it if your income went up or down for whatever reason. So what happened in 2005 is we had a remaking of the bankruptcy laws, and what was happening in a lot of cases was actually high income people would abuse debt, a lot of unsecured debt too. They'd get credit cards and on, and they'd run them up, and they would accumulate all kinds of debt, and then they would simply file a bankruptcy and get rid of the debt, and bankers and credit card companies, they kind of argued about that. And as a result, they passed a law which said, now the judge has the right. You might go in and want a Chapter 7, but the judge has a right to say, sorry, we're going to take a look at your income, and if you've got a reasonable income, we might put you in a Chapter 13, which means that we're going to take a certain percentage of your income and use that to pay back even some of those unsecured creditors like credit cards, etc. So. When a bankruptcy happens, there's a trustee that's appointed by the bankruptcy court. Generally, those were complicated ones that actually had a trustee. Might not be that bad of a job, actually, to be a trustee in a bankruptcy court. You'd get control over the finances of individuals, but certainly some companies, too, that might file Chapter 11s or 7s. Oftentimes, it was called a DIP, or debtor in possession, though, where the debtor would technically be the trustee. Okay, so they were under orders by the court to act in a certain way, but they retained possession of their own finances and whatnot. Okay. Creditor priority classes have to satisfy debt by classes, and that oftentimes had to do with security interests. Okay, who had a priority based on security, and I think we talked about that in some prior chapters regarding property and whatnot, and liens that you could file. A mechanic's lien would take precedence over a bank lien, which would take precedence over an unsecured or second lien holder, those types of things. Discharge of further obligation by debtor to creditor, right? Certain debts cannot be discharged, and I think we talk about those. Goals, again, discharge. We've already talked about 7 and 13. We didn't talk about 11. And Chapter 11 is a business reorganization. So much like we talked about 13, where an individual can reorganize their debts, in a Chapter 11, a business can file the reorganization. There's been some major companies that you do business with that have filed Chapter 11s and come out of it successfully. One is Northwestern, that takes care of our heat and electricity for Havre. Okay, they've actually been through a Chapter 11 bankruptcy several years ago. Another one's Kmart. Kmart filed a Chapter 11 business reorganization, and then afterwards, after they came out of that, not that long afterwards, they bought Sears. It was an interesting time period there. Now, that said, they're still struggling, and it's actually called Sears Holdings, which has Kmart, and they're actually still struggling. So, U.S. bankruptcies, you can see here's where the law changed. We talked about in 2005, and coming up to the law, there was a rash of filings. People were taking advantage of the existing law, and then boom, the next year it just dropped to almost nothing, and it's been coming back up since then. In 2007, 2008, 2009, there's probably a rash of bankruptcies as people were underwater on their houses, especially. And business bankruptcies, you can see they just kind of hang along down here. We think sometimes there's a lot of them, but the truth is, not a bunch really. So, kind of already talked about Chapter 7 liquidation, right? So the trustee takes over and liquidates, pays creditors according to statutory. And Chapter 7 is for either business or individual. That's important to know. Okay, Chapter 7 is for either businesses or individuals, and it's total liquidation. Again, especially as an individual, you might be allowed to retain possession of some of those assets, but you don't get to stop paying. The other thing too that might be important, let's say you had a $200,000 house, but you only owed $20,000 on it. Okay, you would probably either have to pay off that house, or the court might say something to the effect of, we want you to get a loan for the house, for a certain percentage of the house, okay, and those monies are going to go to pay other creditors. They could do that. The court could ask you to do that. Court would ask a bank maybe to intervene and do that, and the bank would be given a priority security interest for something like that. We had that happen a time or two, mostly in some farm agricultural operations. Excuse me, a little tickle in my throat, but in ag operations, we were asked to at times step in maybe and provide some short-term financing, operating type loans for seeding or feeding cattle or such. We were given pretty good protection by the court. Basically, whatever gets sold first is coming to you. Okay, and sometimes there was temporary financing that was needed like that, but it was under the court's direction. And that might be the case if you were asked to, as a lender, to step in and lend some money on a house or vehicle or something like that. Non-dischargeable debts. So we'll go back a couple slides and we talked about debts that you can't get rid of in bankruptcy. You can't get rid of a paternity. Okay, so if you're a dad or mom, it could be maternity, I guess, too, but you can't child support, right? Alimony, maintenance, those are all the same. Taxes, IRS tax liens don't go away. I think property tax liens can. Student loans, sorry. Okay, you can't discharge student loan debts in bankruptcy. For a while, in fact, when I first started in banking, that was common practice. Doctors and lawyers, the lawyers, it was joked, that their first action when they get out of law school was to file their own bankruptcy and discharge their student loan debt. And then their second action was to do it for any doctor friends that they had. And they put a stop to that. Okay, and that was long before 2005. So they put a stop to that practice, and they said student loan debt just simply can't be discharged. Some exemptions, again, things, your residence, your vehicle, some household goods, jewelry. If you got a $150,000 Hope diamond or something, sorry, right? But your wedding ring and those types of things, you're not required to sell. Okay, tools, especially tools of the trade, but basic tools and stuff that you'd have around the house. Again, if you've got, if you've got a well-outfitted shop and whatnot, the court might say, yeah, okay. Life insurance, health aid, Social Security benefits, some miscellaneous things, right? But you don't, especially in terms of residence and vehicle, you wouldn't, if you've got loans out and you wanted to keep those, you're going to have to keep paying those loans. 13, we've already kind of done that. Creditors, it says here, are paid in full, but over a longer period. That's not always the case, and I saw that often with medical bankruptcies, Chapter 13s. Again, a guy I had was a good customer, but his wife had incurred all kinds of medical expenses, no fault of their own whatsoever, and he had to file, or they had to file a Chapter 13 bankruptcy, and he paid X. It was a full amount that the court said he could afford to pay every month, and he did. And it was never ever going to repay the creditors in full, but he was going to pay that the rest of his earning life anyhow. and he did, right? So creditors weren't always paid in full, and they could be forced to take a smaller amount, like in a case like that. Okay, Chapter 11 is strictly a business reorganization, right? The business can continue to operate. Okay, it can be under the court control. We might take a look at those restaurants down in Great Falls. They might end up undergoing, like a Chapter 11. We'll see. I don't know. Payment schedules are established to creditors, so all kinds of financial information goes to the court, and they review it. The creditors and debtors show up in bankruptcy court. Yes, I had to do that several times, mainly with some ag customers, but I think at least one commercial. And you go through it, and you accept the plan, okay, or you fight the plan in some cases, depending on the operator. Probably the most often that I saw in some of the ag ones that I had to go to bankruptcy court is we were asking the court to take them from a reorganization and force them to liquidation, because we felt that they were unable to operate anymore effectively. They just weren't good operators. And I think a couple of times we were successful in doing that, and so it really forced them out of the business. And we took our lumps immediately instead of waiting for 5 or 6 years, and for folks that didn't bother to feed their cows in the winter and things like that. So additional ones, Fair Credit Billing Act. There you go. Limits liability, $50 on lost or stolen credit cards, as long as you report it. Okay. Electronic Funds Transfer Act, same thing. Consumer Product Safety Act, right? We're protected from unreasonable risk of harm from consumer products, and so again, certain things we buy, we assume some risk, right? If you buy a gun, okay, you assume that there's a little bit of risk, right? Magnuson Moss warranty, I have to go back and look at that. I think that puts in place implied warranties, if I remember right. I don't think I have any questions about that on the test, but you guys might want to look that up. I'm not remembering that off the top of my head. Food, Drug, and Cosmetic Act, good about the things that probably prevents them from using animals and whatnot for testing and some other things. Various labeling laws and some of the warnings and stuff, and then state, of course, can have more stringent consumer protection laws. I don't know that Montana goes out beyond what the federal does. If you went to California, they certainly would, right? So consumer privacy has become a big deal, of course, with HIPAA, your healthcare providers and what they can say and what they can't say. That even, I ski patrol, right? And that even comes to us. If I get a kid that falls and breaks his arm, up on the hill, I can tell other ski patrollers, of course, because we need to be aware of it and what happened, and I can tell the kid and his family what I think happened, but I can't go tell other people. So, kind of restricted on some of those things, and again, it's gotten fairly broad to whom those restrictions apply. Right to Financial Privacy Act too. Then you can't. The business can't disclose, a lot of stuff about your interactions. Banks, other financial institutions can't disclose things that you do. Even, investment firms and those types of things. My broker can't disclose to other people what my investment choices are. He could say generic things. He could say, I got this customer that really likes ABC Corporation. Okay, and that's fine, but he can't say, hey, I've got Byron Olfus, by God, he likes ABC Corporation or whatever. So, and this is, the Right to Financial Privacy Act. I always found this interesting in banking, because so much that you did was also public information. Somebody takes out a mortgage loan, that gets filed with the court or with the county, and so it's public. So a lot of that information is public, and yet you're kind of responsible for keeping it sort of private. And it was always a little bit ironic, I kind of thought. So electronic communications, this is new stuff, right? I mean, wow. New stuff that I'm not all that adept at, but we got the Electronic Communications Privacy Act way back in 1986, right? Targets government agencies seeking information, yeah, right, and bring on Mr. Snowden, okay, and what's happened there. Okay, Children's Online Privacy Act, so they can't collect online data regarding children without parental consent. I was just reading about Google and how if you've got an Android device, In fact, police do go in and they'll especially for older cases, they can get tracking information about you from as long as it was 6 months ago or earlier, right? So a long time ago and whatnot. And so they can go and see what your normal thing was, where you went, what you did kind of, and things like that. And it was amazing, the article talked about the dossier that they could create for an individual based on what they did if they had Google Android type devices. EU ban. So the European Union banned without consent cookies. So it probably had to be more proactive, meaning that if you went to a website and whatnot and they wanted to put cookies on, you probably had to agree to allow that to happen. Will the USA follow? And I notice some companies that do that, I notice I get a warning, food for thought. Remember, employers may monitor your email and other computer use at work. Yeah, but your computer and your email are absolute property of your employer, and in fact, your employer is required to keep email records. So not just monitor you, but they're required to keep email records that you might have in case it comes up and is necessary as evidence. Okay. In most cases, voicemail and telephone usage is still protected. That's kind of interesting. You can be prohibited, though, from making personal phone calls. There's nothing wrong with that. Okay, your employer can say, again, it's their phone system, and it's their time. You're using their time. They can prohibit you from making personal phone calls. So, debtor and creditor relations. So we're kind of getting back to a little bit of that consumer report and those types of things. We'll talk a little bit about those. But right, creditors have a right to collect judgments. And if you remember, we went back and we talked about obtaining either default judgments or other types of judgments. Liens can be put on by mechanics, artisans. Artisans are just people that provide specific trades, maybe. Adjusters is ag, so horse keepers they used to call that, but it could be, if you house your cattle or a sheep or someplace and you're supposed to pay rent, right? They could retain, the cattle or sheep if you didn't pay your rent. And they could go through a lien process and file an adjuster's lien. So you can get an attachment then to property if you get a judgment. You can get a writ of execution. The court would grant you a writ of execution, which allows you then to kind of go after that property. Difficult to get a lot of physical assets during a writ, if you get a writ of execution. You could do that. I never did that at the bank. The process was cumbersome, and oftentimes the reward wasn't deemed to be that great. And what that would mean is if it was, if we had a lien against a car or pickup or something like that, certainly we'd repossess that. That was never an issue. But if somebody owed us money, say unsecured, and I thought that they had a pickup, I could go after that pickup using a writ of execution. But I might find out when I got further along that there was a mechanic's lien that was going to be placed on the pickup, and there was another lien ahead of me, and on and on. And so we usually found that to be not that productive. But we could use this to go after people's bank accounts. So if I knew that Joe had a loan with me and he didn't pay off, and but I knew that he had a checking account over at Wells Fargo, I could take a writ of execution and send a service processor over there, and if he had money in his account, they would take it out and send it to me. Okay, they'd write me a check for it, and we had that happen the other way too, where folks would bring a writ of execution into our bank, and we'd have to do that. Garnishment used too on occasion. That's where you take a certain portion of a person's wages. You can take up to 25% is all the court will allow, and then foreclosing your interest on other things. So debtors have rights, and we talked about this. This is again in bankruptcy, homestead exemption, personal properties can be exempted, and we kind of already talked about that. There's credit scoring, right? It's gaining, so it's more and more. It's actually being used more and more. We're kind of becoming a nation of haves and have-nots. Lenders, insurers, landlords, many others, employers, they can do that. They need to disclose to you and perhaps get your permission. Say, for example, as a landlord, I could say, I want to check your credit report, and you're signing this gives me permission to do that. Okay. Boom, I'd have permission. Could I deny you then access or deny to rent to you if you didn't give me permission? Yeah, I could. Okay, and that might be the same with insurers and certainly lenders and whatnot, right? I think this is a little bit my opinion, but it's creating kind of a haves and have-nots. I mean, either your credit score is good or it's not. If it's good, you have access to all kinds of property and those types of things. Okay, we used to speak of a 620 cliff. I think that that it's gone up now. I don't think that the cliff is quite as definitive as it was in the past. I mean, 620 used to be kind of the cutoff in the industry. If you were less than 620, sorry, you didn't get access to bank credit. If you were more than 620, then you were a reasonable risk. That's gone up. You know, that number's gone up again, probably since 2007 and since that crisis that ensued. They contain what's credit report contain trade lines. That's where you're like farm plan, you know, where you might be borrowing money using trade types of things. Your loan history, that's history that you have with banks and those, you know, other lending institutions, I guess. Collections. So if somebody had to collect on you or they turned you over for collection, that could show up on there. So I've had that. You know, I've had people leave as a landlord. I've had people leave and owe me rent, and rather than me pursue the legal actions and whatnot, I would turn it over to a collector, Credit Bureau of Havre, and say, hey, you guys go get that. And then we would split based on what their charges were. We would split what they collected. Okay. Legal actions, some of them can show up on there. Usually criminal activity doesn't, but legal actions that involve debt. It might be a legal action to force you to pay child support, those types of things. The main providers of those, TransUnion, Experian, and Equifax. I usually throw those on the test, and I usually, you know, give you a name that sounds kind of like one of them, so make sure you know those. These are the three major credit reporting agencies, okay? TransUnion, Experian, and Equifax. Oops, I'm sorry. I want to make sure I didn't miss one there. Okay, we have the right, okay? Requires that we have the right to obtain free access to our credit report. That's not necessarily our credit score, but we have rights to our credit report at least once a year from each of those three agencies. Okay, and you can do that by going to www.annualcreditreport.com, and that'll be on the test. Okay, www.annualcreditreport.com, and we should do that. Okay, usually in the spring when I teach this class face-to-face, that's kind of when I say, okay, I better go check my credit report out, and so I'll go through that. It's a bit of a process. I'm not going to tell you that it's just painless and easy. It takes you 15 or 20 minutes to get through it. They're going to try to sell you some stuff. Okay, they have a right to do that, so you got to click through those, you know, and make sure you don't buy something you don't want. I've had some folks lately, because I haven't done this for a bit, but tell me that they were able to actually get a free credit score when they did that as well. And in the past, that wasn't the case. Okay, but you'd get a credit report that would tell you if there was adverse information or stuff on it. It's good to do because of all the identity theft and stuff that's going on. Because if there's something that's on there that shouldn't be on there, then you start writing letters to get that taken care of. And it does take letters. I had a buddy who went to refinance his house probably 7-8 years ago, and when he did so, he was originally denied because they said he had some adverse credit on there, and he said, what? You know, he thought his credit history was perfect, and he looked into it, and somebody had used his information, had stolen his identity, gotten a credit card in Pennsylvania, ran it up. It was only $500 or whatever, but obviously they ran it up, used it, and then didn't pay it back. Well, he'd never been to Pennsylvania in his whole life, didn't have any relatives there or anything, and knew nothing about it. And so it was a case of identity theft. And he called, and we'd BS. We'd go out for lunch, and he'd say, oh, I called, and they were going to take care of it. They promised me, and I'd keep shaking my head and saying, you know, you got to write a letter. And they wouldn't respond. And finally he wrote a letter, said, they screwed up, you guys screwed up, fix it. And then they did. and in relatively short order. Of course, you need to threaten to sue them and do those types of things. So, yeah, this is a little premature here because this used to be the last thing that we talked about, but that's what we have coming up. So soon, we got a little ways to go. All right, so that's it. Kind of a hodgepodge of information there about credit. I hope some of that is stuff that you can use personally. It ought to be. I mean, there's some reasonable information in there that you ought to consider, and you ought to get that credit report, and you ought to look at some of that stuff because it is important. So with that, I will bid you adieu, and we shall talk again next week.